Good morning, good afternoon, good evening. It's my great pleasure to moderate today's webinar, which is the launch of the commentary on the 1970 UNESCO and 1995 UNIDROIT Conventions on stolen or illegally transferred cultural property. The volume was published last year by the Oxford University Press. I'm Andrzej Jakubowski, Vice Chair of the Arts and Cultural Heritage Interest Group of the American Society of International Law and one of the editors of this commentary. I would also like to welcome you on behalf of Dr. Shia Esterling, Chair of the ACIL Interest Group, and my co-fellow editors, Professor Anna Filipa-Wdojak and Dr. Alessandro Cecchi. I extend my warmest welcome to our esteemed panelists, Patty Gerstenblit, Distinguished Research Professor of Law, Faculty Director, Center for Art, Museum, and Cultural Heritage Law, DePaul University College of Law, and James Nafziger, Thomas Stoll Professor of Law, College of Law, Willamette University, Vice Chair of the International Law Association, ILA, and long-standing Chair and good spirit of the IL Committee on Cultural Heritage Law and the former ACIL Administrative Director. They are both the authors of the commentary. We are delighted that Giuditta Giardini, an expert on the 1995 UNIDROIT Convention and the Chair of the Legal Affairs Committee of the International Council of Museums, ICOM, has accepted our invitation to join today's panel. Please may allow to provide a brief insight into the commentary. This project has been a significant undertaking involving the expertise of almost 60 specialists from nearly every corner of the globe. It has been drafted in the close cooperation with the secretariats of the 1970 UNESCO Convention on the means of prohibiting and preventing the illicit export, import, and transfer of cultural property, and of 1995 UNIDROIT Convention on stolen or illegally exported cultural objects. The commentary is the first publication to provide comprehensive coverage of these two leading multilateral treaties on movable cultural heritage in a single volume. The study provides an article-by-article analysis of the history, interpretation, and application of the two conventions. It also examines the regimes in the working context of other cultural conventions, including the World Heritage Convention, Underwater Heritage Convention, Intangible Heritage Convention, and the 1954 Hague Convention and its protocol, and its protocols, as well as related fields of international law, such as international criminal law, human rights, and international economic. The introduction by Anna Filipa-Wdojak will be soon available in open access on the website of the Oxford University Press, along with the new promotion code to purchase the volume. This information will be communicated on the interest group page. The webinar also aims to provide a timely opportunity to commemorate two significant anniversaries. Firstly, the 55th anniversary of the adoption of the 1970 UNESCO Convention, which saw ratification rate of nearly 150 state parties, including major market countries such as the US. Secondly, the 30th anniversary of adoption of the 1995 UNIDROIT Convention, whose acceptance and recognition is growing and has now reached nearly 60 contracting states. This webinar will focus on the key topics of the book: international trade in cultural property, the protection of cultural heritage against illicit practices. It also addressed the value and significance of provenance and diligence in the context of these two conventions, as well as the practical operationalization of the treaties, with particular focus on American practice. These topics will be addressed by our esteemed speakers. Then the Q&A session will follow. And if you have any questions in the meantime, please put them in the Q&A box. Thank you. So thank you in advance for your questions. And now I would like to hand the floor over to Professor James Nafziger, who will address the international treaty framework supporting the international regime for the trade of cultural objects.
Thank you very much, Andre. In the interest of time, I think I will generally be scripted in the sense of reading remarks. I was asked to focus on international trading of cultural objects as well as on restituting or returning of them to countries of origin in some circumstances. 3 multilateral treaties establish a sort of tripod to support responsible activity. First, the World Trade Organization, or WTO, primarily through its extension of the 1947 General Agreement on Tariffs and Trade, otherwise known as GATT. Second, the 1970 UNESCO Convention, and third, the 1995 UNIDROIT Convention. Of course, only the last 2 legs of the tripod I've just mentioned are specific subjects of this book launch, but I want to first spend just a few moments on the WTO framework, even though in practice it hasn't been very important in protecting cultural objects. Article 11 of the 1994 GATT prohibits quantitative restrictions on the import and export of goods. It would therefore appear to inhibit national controls over trade in cultural objects, but the prohibition is subject to an exception in Article 20 for measures imposed on the protection of national treasures, those are the words used in this exception, that are of artistic, historic, or archaeological value. Unfortunately, the precise scope of the term national treasures remains unclear. It has never been the subject of analysis by a GATT or WTO panel, including WTO pellet bite, which topic I'll return in a moment. Some legal systems have adopted the concept of a national treasure, but most have not. What's more, the WTO framework as a whole has been crippled, unfortunately, by a lack of support. For example, the failure of the United States to cooperate in the appointment of new appellate judges, thereby inhibiting the dispute resolution process within the WTO. Although alternative arbitration has been developing. Let me now turn to the second leg of the tripod, namely the 1970 UNESCO Convention. With its 147 parties, those include virtually all of the major art market states, which is important. Even though its overall relationship to international trade law remains somewhat imprecise, it is the most important international agreement for cooperation in deterring and responding to illegal trafficking in cultural objects. Sadly, such trafficking is counted as the third most lucrative range of illegal trafficking, following drugs and armament, amounting to as much as an estimated $6 billion each year. And just as sadly, the estimated recovery rate of illegally trafficked material, cultural material, is rather dismal. A singular achievement of the 1970 UNESCO Convention, however, was the first detailed definition of the term cultural property, which these days is more commonly and appropriately termed cultural heritage. The 1970 Convention has a definition of cultural property that focuses on property of either religious or secular basis, specifically designed by each state as being of importance for archaeological, prehistory, literature, art, or science, and which falls within any of 11 enumerated categories. But let me just sketch the most important provisions of the convention. First, a system of mutually enforceable export certifications by each state party. I might mention at this point that the United States is a party to the 1970 convention, but we have entered a number of reservations that include this one of mutually enforceable export certification apparatus. Secondly, the convention provides emergency measures for parties to call on each other to prohibit the importation of a specified class or classes of cultural property that are in jeopardy as a result of international trafficking. Thirdly, a requirement that parties restitute property within their jurisdiction that has been stolen from museums, monuments, and other institutions. Fourth, a requirement that consistent with national legislation, therein lies the big ambiguity, of course, that parties prevent museums and similar institutions from acquiring property illegally exported from other states. Fifth, a commitment that parties impose penalties or other administrative sanctions for stipulated violations of the treaty. And then finally, a provision for international cooperation in identifying cultural property and developing national inventories. Contraband items are recoverable on demand by the state of origin, so long as just compensation is paid to innocent purchasers. Overall, the convention was designed to strike a compromise between the interests of art importing and art exporting states while requiring the importing states' cooperation in the recovery and retrieval and return of illicitly exported property. Finally, the third leg of the regime is the 1995 UNIDROIT Convention. Its aim was to strengthen the regime established by the 1970 UNESCO Convention by filling gaps that had become apparent in it, particularly involving questions of procedural and private law, such as those related to statutes of limitations and the bona fide purchaser, concerning which, of course, the civil law and common law system differ 180 degrees. The convention uses the term cultural objects, which, however, tracks the definition of cultural property in the 1970 convention. As with that convention, the 1995 UNIDROIT Convention only applies prospectively. It therefore does not apply to objects stolen or smuggled into the territory of a state party before the convention comes into force in that particular state. Chapter 2 of the 1995 UNIDROIT Convention concerns the restitution of stolen objects. And the term stolen cultural object is expanded from the 1970 convention to include objects unlawfully excavated or lawfully excavated. We're talking obviously about archaeological objects, but unlawfully retained, consistent with the laws of the state where the excavation took place. Claims for restitution of such objects must be within 3 years after the claimant actually discovers where the object is located and who possesses it. What we know in our US and common law system as the discovery rule and procedure. Also, all claims must be made within 50 years from the time of theft. There's more to that, but I have to defer any further discussion to our Q&A. Persons required to restitute stolen cultural objects are entitled to fair and reasonable compensation. due diligence must be exercised, and that is defined within the 1995 convention. Chapter 3 of the convention concerns the return, not of, in the sense of restitution of stolen property, but the return of illegally exported cultural objects. Such objects must be returned on the request of a state party to the courts or other competent authority of another state party if its loss significantly impairs one or more of several interests that are identified. Andre, in his introduction, noted that a number of other international instruments play a role in this regime, generally positive, but I'll just mention that generally the role can be negative, and I would cite the 1954 Armed Conflicts Convention, which is an extremely important, seminal convention on cultural heritage. But my own chapter in the book we're talking about is on Article 11 concerning military occupation, and I have described it as an orphan. It has been almost totally neglected because of the dominance of the 1954 convention, and that's too bad because Article 11 has the advantage of being within a comprehensive convention with ties to the other provisions. Finally, in the 1 minute I have remaining, I'll just mention that there are a number of ambiguities as well as successes of the convention since they're being put forward that we can take up in the Q&A. Let me just conclude by quoting Professor Janet Blake, leading commentator and scholar on cultural heritage issues. In many ways, she observed, the institutional and awareness raising aspects of the 1970 convention have been its most effective elements. So let's not expect too much out of these conventions. There's an enormous amount of commentary in the book we're discussing about the fate of the conventions and indeed considerable success. But I think it's enough to agree with Janet Blake. Thank you very much.
Thank you so much, Jim, for this providing us with this wider picture, which I think that opens many points for further discussion. And now I would like to invite Professor Patty Gerstenby to take the floor. And Professor will consider the current importance of provenance research, due diligence in the acquisition of cultural property.
Thank you so much, Andros, for inviting me to be part of this webinar today. And I especially was honored to have contributed a chapter to the commentary itself. I have to say the three co-editors undertook an absolutely Herculean task, and it's a huge accomplishment to have corralled so many of the authors. Many of the chapters, maybe all of them, had co-authors, so there was double the number of authors that you had to deal with. And so to me, it was an amazing accomplishment that you all managed to complete. So yes, Anders asked me to talk about a number of topics, including the issue of provenance research, although to some extent that fits more. I will talk about it, but of course it also overlaps with the UNIDROIT Convention that Giuditta Giardini will be discussing, and she will be discussing it in more detail and in terms of the UNIDROIT Convention. But provenance research is really key. It is the essence of preventing illegal objects and trade in those objects from coming onto the market. This is important because when things come to the market and are sold, that puts money and financial incentive into the market that works its way backwards to the people who are themselves initially engaged in theft or looting. So to prevent these objects from being sold, the crucial thing is to prevent buyers from wanting to buy. And to do that, negative consequences need to be imposed on them through the law, but they can avoid those negative consequences through proper provenance research. And let me okay, there we go. So the 1970 convention addresses both what we can call documented and undocumented cultural objects. And we can think about documented objects. They can be archaeological, but they can any other form of artwork that were known and usually documented in some kind of a collection before they are either stolen or illegally exported. So this is just an example of an object that was documented in the collection of the museum in Baghdad and stolen in 2003 and purchased by a museum in the United States, the Michael C. Carlos Museum at Emory University. It was eventually identified and returned to Iraq in 2023. The convention does deal with documented, and I'm going to talk a lot about the U.S. implementation of the convention, to which Jim Nafziger alluded. So the U.S. did adopt parts, but changed how Article 7 of the convention was adopted, but it prohibits the import into the United States of documented cultural objects from a public collection that is stolen after the date on which both the U.S. and the date for the U.S. is 1983, and the other country have become state parties. So this is just two examples of objects that were seized and forfeited under the U.S. implementation of the convention, an altar from a church in Peru, and this tomb relief that was chiseled off the wall of a tomb at an archaeological site in China. And both of these were recovered under, as I said, our implementation of Article 7. The bigger challenge is how to deal with what we can call archaeological theft. That is the looting of archaeological objects directly from the ground. They are not documented and generally are not known until they appear on the market, appear crossing a border, or in a collection, perhaps a public collection, or something that's owned privately and is loaned to a public collection. And that way they become known. I tend to focus in my own work on archaeological artifacts, but the same thing can be said for other types of objects that may not be documented, including indigenous cultural objects that frequently are not documented because it may be contrary to the religious practices, traditional practices of the community from which they come. Dealing with these from a legal perspective are more challenging because of their unknown nature, and that actually makes them fit well with other kinds of criminal activity. Now, Jim mentioned that the U.S. ratification eventually in 1983, although the Senate gave its consent to ratification in 1972, but did so as an executory treaty, meaning that domestic implementing legislation was required. This is the Convention on Cultural Property Implementation Act, often abbreviated. In the Article 7 that I mentioned before, implementation, that was not such a big change from existing U.S. law, which already prohibits the import, trade, possession, et cetera, of stolen property. But in the other area of undocumented objects, we get a bigger change. So first, the convention itself deals with this under Article 3 as applied to the broad category of cultural property. And I'll mention, I was going to say my neighbor to the north, but I'm actually located in Italy at the moment. But the U.S.'s neighbor to the north, Canada, along with many other market states, particularly in Europe, have implemented Article 3, making the import, export, or transfer of cultural property, contrary to the provisions of the convention, illicit. Now, they do so by adopting what I have called reciprocal import restrictions. So something whose export is restricted under the convention cannot be imported unless it has an export license. And Canada is a good example of this. I have here on the screen the citation to the exact part of the Canadian legislation. And Canada has, in fact, intercepted many objects through this provision and has returned them. I will also mention that this article, I believe, has inspired, perhaps, or at least encouraged, the new regulations that are supposed to come into effect this month for the European Union that will, for the first time, restrict imports of objects from non-EU member states. This is an extremely important development and expansion. I know it falls outside the US, or North America, but it's still an important intersection between things like the 1970 Convention and other both international, regional, and domestic developments that reinforce each other and reinforce the convention. Now, the second major prong of U.S. implementation of the convention is actually of Article 9, not Article 3, and it's restricted to archaeological and ethnological objects, and establishes a very complex system in which the U.S. will enter into additional bilateral agreements to impose import restrictions for illegally exported archaeological and ethnological objects. The chapter that I contributed to the commentary focused on Article 9 bilateral agreements, which for many countries are cooperative agreements and do not establish new law. But in the case of the U.S., these agreements establish new law. It's a very complicated system. I'm not going to bore you all with it, and I don't have enough time, but I'm happy to answer questions in the Q&A. But the United States currently has 29 bilateral agreements or memoranda of understanding under Article 9 of the Convention, and has also imposed 5 emergency import restrictions that are shown in the yellow and the green. 2 of these by special legislation for Iraq and Syria, and 3 others for Ukraine, Afghanistan, and Lebanon. The chapter that I contributed was co-authored with Professor Wang from China, and our chapter focused not only in general on the U.S. implementation, but specifically on the bilateral agreement with China. And this agreement has been in effect since 2009, and I think demonstrates well that countries will often be willing to cooperate and talk with each other no matter what other political tensions there may be between the countries, that we can have these agreements. They establish a framework for bilateral relationship. It's not just import restrictions, which is what people tend to focus on, but it also is a framework for protecting heritage in the other country, the country with the agreement, and also for enabling things like museum loans and other forms of cooperation between the United States and those countries. I want to mention 2 other aspects of law that overlap, perhaps this one more with the UNIDROIT Convention. Jim Nofziger mentioned the particular provision of Article 3.2 of the UNIDROIT Convention, which dovetails to some extent with the U.S. adoption and now several other European countries as well. The doctrine that foreign national ownership of archaeological objects means that those objects, when taken without permission, are considered stolen property in the United States and in other countries as well. So this is a very similar, a reinforcement to that Article 3.2 of the UNIDROIT Convention, which also was helped by the model ownership law provisions established jointly by UNESCO and UNIDROIT. The last couple of cases I'm going to mention all involve examples not only of violations of the law, but also where provenance research was not done sufficiently and where involving forged or faked documentation. This is a gold fiale bowl from Italy that, upon its import to the United States in roughly 1990, was falsely declared as to its ownership and value, and this made it subject to import restriction. This preceded the U.S.-Italy bilateral agreement, and so it was forfeited under different legal provisions. This coffin from Egypt, which was looted in 2011, brought into the United States in 2017, was done so based on a forged export license from Egypt, clearly a failure of adequate provenance research, which quite honestly, maybe I shouldn't be quite so strong about this, but it's actually shocking that this forged license was not detected. This and perhaps other examples have led to several museums in the United States expanding their provenance research efforts. The Boston Museum of Fine Arts was the first museum, at least in the United States, to have a full-time provenance researcher, Dr. Victoria Reed, with the title of Curator of Provenance. Now, several other museums, including the Metropolitan Museum, perhaps as a result of this case, the Art Institute in Chicago, now have a team of full-time provenance researchers. And personally, I think this leads the way of the future of how an important element of this field will develop. And finally, the Hobby Lobby cases involving, on the upper right, you see the cartons, the crates with 17,000 cuneiform tablets and other objects being returned to Iraq, imported based on false documentation, again. And on the left, the Gilgamesh tablet returned around the same time that Hobby Lobby purchased for close to $17 million, again, based on improper provenance information, which led to incorrect false statements on the import documents, which led to the basis for an agreement of forfeiture. So these conventions, their implementation into domestic law, and enabled through better provenance research to prevent the violations of law, I believe are where these conventions have made their contribution and the direction in which these issues will go in the future. So thank you for your attention.
Thank you so much for this very rich presentation, and also referring to these really important cases. I think many of our participants are familiar, so this was with these cases. So it was really important also to this links with the regime of the two conventions. So thank you so much. Now Judita will focus on the role of UNIDROIT Convention in the current international practice of returning and restituting cultural property. Also, perhaps Judita, maybe you also explain the benefits of becoming a contracting party to this treaty. So, Judita, the floor is yours.
Thank you. I hope you can see my screen.
Yes.
Sure.
Not yet, not now. Could you? I cannot. I think we cannot share. Could you reshare your screen?
Yes. Can you see?
Yes. Now, yes.
Okay, perfect. So good morning, afternoon, or evening, everyone. I would like to start by expressing my admiration for the authors of this volume. It is a monumental achievement, and so we are all familiar with the significance of the two editions, Patrick O'Keefe commentary on the 1970 UNESCO Convention, Lindelproth commentary on the 1995 UNIDROIT Convention. But I guess this volume, we can all agree that it's something different. And it puts the two conventions in dialogue in one coherent text. And it stands firmly on the shoulder of those foundational works, but it dares to look ahead towards cooperation and convergence of these two important tools. So as last to speak, it's not an easy task, especially after Professor Napsinger and Professor Versenblit, both authors of this commentary and speakers. Can you hear me fine? Because I hear some echo of my voice, so I don't know if it's...
Yes, sometimes there is echo, no, sometimes I don't know how to...
Okay.
But please continue. Maybe colleagues in ASIL will fix it.
Okay. So I was saying that it's hard to speak after two of the authors of this book and speakers today were among the world's best experts on this subject. To cover up for that, I'll just stick to the facts, and I hope by that to contribute something meaningful. The UNIDROIT Convention, the 1995 UNIDROIT Convention, complements the 1970 UNESCO Convention by establishing uniform rules for the restitution of stolen cultural objects and the return of those illegally exported. The convention today counts 56 state parties, and after initial wave of accession, as you can see from my slide, after initial wave between 1998 and 2005, ratification slowed, with only occasional accession in the following years. However, there has been a renewed momentum since 2012, with Morocco, Mexico, Uruguay, and Yemen recently joining. Some countries, as you know, have signed the convention, like Russia, France, the Netherlands, but have not ratified. And although the United States ratified and implemented the UNESCO Convention through the CPIA that Professor Gerstenberg was talking about, in the initial order was in the 70s, but the implementation happened with the Act of 1983. The United States has not ratified the UNIDROIT Convention yet, we'll say. So, although not being a contracting party to the UNIDROIT Convention, the US is among the countries with the highest rates of cultural object restitution and return. Professor Gerstenberg also mentioned in her presentation. Since its creation, for example, the Antiquities Trafficking Unit at the Manhattan DA's office in New York recovered almost 5,800 antiquities worth close to $460 million, and more than 5,250 objects have already been returned to 29 countries. And we're also seeing a growing trend of voluntary returns by US museums, and Professor Gerstenberg mentioned that several factors are really driving the shift. First, museums are taking a more proactive approach, which is great, to provenance research, especially when records of the objects in their collections are incomplete. They also they hired provenance researcher, they set up provenance research department. And as Professor Gerstenberg said, the Museum of Fine Arts in Boston set an important precedent by hiring the first full-time provenance researcher, and other museums follow, like those you see in the slide, the Worcester Museum of Art, the Met. And also institutions increasingly recognize that provenance research is not just about transparency, but it's also about addressing past acquisition practices that wouldn't be acceptable today, like the optical due diligence, and not a practical one. And also there's been a rise in collaboration with countries of origin, which is very important. So in this way, as the preamble of the UNIDROIT Convention also says, the beginning of a process. And finally, activism and public pressure, especially from NGOs and local scholars reframing restitution and return as a matter of justice and cultural dignity. So when when presented with these figures and these new practices, one might ask, why should the United States consider acceding to the UNIDROIT Convention? After all, the current system seems to be working sufficiently well. However, many of the objects that have been and will be recovered from good faith, were recovered from good, or will be recovered from good faith possessors, like collectors, dealers, or museums, who were often proved, or sometimes proved, to be unaware of the object's problematic provenance. Therefore, the fact that the ultimate buyer, or let's say of a stolen object, acted with due diligence from a private international law perspective, not a criminal one, is a factor that does not really weigh in the equation of restitution. And not considering good faith or not, at least from an international private law perspective, it's very important, like a loss for a market country like the United States, a country with the largest art market in the world. So the good faith purchase of cultural objects a non domino, meaning the purchase from a person different from the owner, is in general irrelevant, in US law, with some notable exceptions, known as a doctrine of entrustment and voidable title. And an example of entrustment is the owner give a valuable vase to an antiquities dealer who deals in this kind of goods to clean, restore, or to have it appraised. And the dealer, without permission, sells the object to someone else. And if that person is a good faith purchaser, in the ordinary course of business under UCC 24032, they get a valid title and you cannot get the vase back. So the object back, the vase in the case of the slide. So the rules of commercial law prevent the owner from recovering property that was sold to a good faith purchaser if the owner voluntarily transfer possession to an intermediary, thereby giving the intermediary the indicia of ownership. However, so this is what happens, but the situation, however, must be clearly distinguished from that involving theft of cultural property in which the owner did not voluntarily transfer possession. So there's a crucial nuance for cultural property cases. In most of these cases, there's never a voluntary entrustment by the rightful owner, and the object may have been stolen abroad and then imported and not entrusted. Therefore, the object, for example, in the example of the slide, is seized and returned to country A, and also requests of refunds are difficult to obtain. So as I said, if stolen object is found in the hands of a good faith purchaser, in the cases that we've seen, I mentioned before, it would most likely be returned to country A, and with no compensation for the good faith purchaser. Now imagine if that same looted cultural objects found in the hand of a good faith buyer had been discovered in the hands of the same buyer, but in a country that had adopted the 1995 UNIDROIT Convention. If the convention applies to the case, meaning that both states are party to the UNIDROIT Convention and the theft of the illegal export happened after the entry into force of both state parties, the convention, then in that case, the legal treatment of the good faith purchaser would have been different. In fact, Article 3.1 established a principle that's very dear to the US, which is the nemo dat quod non habet, that, of course, order the restitution in any case of any stolen cultural objects to their rightful owner. But then the Article 4.1 adds a crucial balancing mechanism and allows for compensation to a diligent possessor of the stolen objects if the possessor, he or she, can prove that they exercise due diligence at the time of acquisition. And what does due diligence mean? Article 4.4 of the UNIDROIT Convention provides a definition of due diligence, which includes like verifying the provenance, as Professor Gerstenblad mentioned before, checking all accessible register, consulting databases, and obtaining documentation related to the objects going back in history. It's an open concept, so it depends. It's really, it's not one definition fits all, but it depends on the nature of the object and the party involved. And also, it's interesting because in the commentary under Article 4.4, it was emphasized that the burden is on the possessor, of course, but it is not an impossible one. It's a very high standard, of course, and it provides clarity and, more importantly, offers fairness, but also legal certainty in the market. Article 6.1 allows also for compensation to a good faith possessor of illegally exported cultural objects when they are returned to their country of origin, if the possessor can prove that he or she exercised due diligence or good faith. Here scholars are debating if the standard is high as due diligence or it is just a good faith to get compensation upon return. And Professor Berde-Mersenne strictly noted that, strictly speaking, none of the factors explicitly mentioned in Article 4.4 should be disregarded in the assessment under Article 6, although the latter does not use the same wording. That's what he says in the commentary. And this interpretation really moves forward from the debate of scholars on whether the standard on whether the standard applied in Article 6 was the same of that Article 4. We'll see in the future. But so another argument that was made against the ratification by the accession by the US of the UNIDROIT Convention was made by Professor John Henry Merriman in 1996. He criticized the recognition in the United States of export laws enacted by countries of origin and he himself withdrew from the preparatory work of what he called La Bella Convenzione, the UNIDROIT Convention, and he did so on the ground that such practice conflicted with his doctrine of cultural internationalism. In his view, enforcing foreign export restriction undermined the free circulation of cultural objects and the shared global heritage of humanity. However, today, with a growing number of restitution and return based on the violation of foreign patrimony laws and export laws, as Professor Gerstenberg also mentioned, an increasing number of bilateral agreements being signed under the CPIA with countries of origin, many countries of origin. There is a growing recognition and also a deference to export laws of foreign nations. So we're moving forward. So although the United States is not a party to the 1995 UNIDROIT Convention, its core values, due diligence, fairness, and international cooperations are increasingly reflected today in the US practice. And from guidelines to the behavior of private collectors, the influence of the convention is clear in some aspects. As the largest, as most influential art market in the world, the US we know that it plays a critical role in advancing legal certainty and responsible trade. So this commentary is really key to understand the potential of an accession of the US to the convention. And it's an extraordinary volume and it does something really precious. It doesn't merely interpret the past, but as Professor Verdoljak put it in her conclusion, it envisioned a future where the 1970 UNESCO Convention and the 1995 UNIDROIT Conventions do not operate in isolation, but in tandem, shaping a coherent and an international framework with strong principles. And thank you and congratulations for this commentary. It's great work.
Thank you so much, Judita, for bringing all these issues together, because especially I think the last part of your talk, like focusing on the way how the treaties really influence also the practices of collectors and art market. I think it's really important, because this was also the scope of this commentary to show not only the direct practice, so based on both judicial on let's say diplomatic solutions state, but also how this regime, how the framework created by the two treaties really influence the behavior of different actors. And I'm very grateful to all of you also for bringing also the issue of archaeologists, also the issue of I mean, Patty mentioned also the European Union, a very important cooperation between this regional organization with UNIDROIT, and also in terms of let's say maybe not unifying but standardizing the test of due diligence. And I think this was really important to mention. And I cannot see the question at the moment, but I would like to maybe ask you, if I may, especially Judith and Patty, two brief questions. So first to Judith, because now we are facing a very important discussion on the new code of ethics of the International Council of Museums. You know, so and you are the chair of the legal committee. So how these two conventions are really taken into consideration while drafting this new global code of ethics for museums? And Patty, if you could, because you mentioned that the convention also the case Boston, the Metropolitan, so how the regime created by these two conventions really change the acquisition policies. No, so how exactly whether we've got like a direct direct reference to these treaties in acquisition policies of museums in the US, or it is just the use of the same language? What is the impact in the acquisition policies of American museums? Thank you.
Do you want me to go first?
Yes, please. Thank you.
The last question. I would say actually the place where the 1970 convention has had a big impact on US museums is in the adoption of what we can call the 1970 standard, which is not a legal issue. I have to emphasize 1970 has no actual legal significance. For each country, the convention is relevant from the time it's ratified and perhaps implementing legislation is adopted. But nonetheless, scholarly associations, archaeological publications, and eventually the two big museum associations adopted, well, I'll call it the 1970 standard. There are differences, but obviously it's in honor of the 1970 convention saying that objects should not be acquired unless there is a provenance showing that the object was out of its country of origin by 1970, or evidence of legal export from the country of origin. So this actually goes far beyond anything the convention does. It goes beyond the bilateral agreements, but these were not really adopted until 2008, which is relatively recent in the history of the convention. But this probably, as an ethical, voluntary guideline, which I have to admit is often, there are many exceptions that are allowed under these policies, and these exceptions are sometimes used pretty broadly and liberally by certain museums. But nonetheless, I think that that was a major impetus and actually influenced indirectly by the 1998 Washington Conference principles, because the first area of provenance research actually was related to Holocaust-looted art, which is not directly relevant to the conventions. And I guess I would say that as these bilateral agreements have increased, it becomes more and more important for museums to also engage in the research to show that they're not violating one of the agreements, which are complicated and different for different countries and cover different materials. But that's the basic concept. But I think the single largest impact was probably this idea of the 1970 standard.
Thank you so much. Thank you for this clarification. Thank you. Judita, could you?
Yes, thank you. So I don't want to give spoilers on because the new code of ethics will be maybe brought to Dubai in November 2025 for adoption, maybe not. We're still, I mean, the executive board will decide next week, ICOM, so it's still under consideration, but if it's not this year, it will be the next. So there have been many changes. And of course, international conventions are like the UNESCO and UNIDROIT Convention play a crucial role. But I just want to share with you that it's very hard sometimes to pass this message that the situation we're living now, it's also based on the past work of the conventions, because sometimes we're having this conversation with museums people, and they believe that they convention don't really apply to them, and they have some practices that, for example, they say we're returning objects without legal tools, without conventions, and we don't need international convention to repatriate objects, to sign a protocol. It's kind of hard to sometimes to make them understand that today's achievements were possible thanks to the work done by the international communities and also the developments brought by these treaties, which are very important. Like, for example, now we take due diligence for granted, but when it was when the UNIDROIT Convention was adopted, due diligence was like a revolutionary concept in the art market. And that's why the convention was not very well received by the market. So we're having interesting conversations. But yes, definitely both treaties play crucial roles in the code of ethics and in setting the standards for museums, staff behavior and acquisitions and all the other policies. Thank you.
Thank you so much. No, because I think this moment, this momentum that we are now facing the discussions, like also in the national committees, national commissions of ICOM, in many states. So we are on what would be the standards, and how to. I think this is a really important time for all the society, global society of museums and museum officers to really discuss this due diligence aspect and of provenance research, and also in terms how the future policy of acquisition exchange will look like. Jim, yes, you would like to.
Yeah, just very briefly, I wanted to underscore the conclusion that Patty Gerstenblith came to about the importance of the standard under the 1970 convention. But proceeding from there, I think that the 1970 convention not only has reshaped conduct of museums and other institutions, but more broadly, I think it's reshaped public expectations about the role of museums and other institutions, that they have an ethical responsibility. They must comply with standards. And I think that is a very important development for the public as a whole. I just wanted to also mention again the fact that among the reservations that the United States has to the 1970 convention is to what I think was originally designed to certainly be one of the most important provisions, namely a process of export certifications that would provide the basis for legal trade in cultural material. And of course, the reservation is not too surprising given the reluctance in our legal system for virtually the entire history of the Republic to enforce foreign revenue and other public laws. And this, of course, tracks that reluctance. But in any event, I bring that out by way of also noting that I think we're about the only country, certainly the only major country, that has no program, no legal provisions that explicitly address export of cultural material. There are indirect controls, for example, related to material taken from public land or indigenous material, but we remain unique, I think, in not having export controls, and that's something perhaps we can talk about later. But I just wanted to bring that out as an example of something very important, or designed to be important, in the 1970 convention that has simply resulted in a reservation by the United States to the 70 convention. Thanks.
Thank you so much, Jim. Thank you so much for these comments. It's also for this important statement that the convention really changed the expectations of the general public towards museums. I think this is also really important how we see the role of museums today. So thanks to this treaty. So I think our time is over. So I would like to express my sincere gratitude to the panelists and all the participants. Now we had many people online of this meeting. So I'm very so on behalf of the interest group and behalf of the creditors and authors of the. Thank you very much for joining us. And also let me thank to the entire team of the American Society of National Law for making this webinar possible, and special thanks to Britta Jelen and James Steiner. So thank you again and have a good afternoon or good evening. Goodbye.